Good morning, Alex and friends. I'm Grace. Today is Wednesday, December 3rd, 2025, and you're listening to Alex's News. The high in Riverside today is 68.5 degrees, with a low of 51.8, so expect a mild day with comfortable temperatures for getting out and about. Coming up, we'll examine the reasons behind President Trump's move to pause immigration applications from 19 countries deemed high risk for security threats, and break down San Francisco's legal action against major food companies over their role in a growing public health emergency. Plus, other stories on global developments, local impacts, and more to keep you informed. All this and more coming up on Alex's News. Stay tuned. Good morning. The Trump administration has paused a wide range of immigration applications for people from 19 countries. Ethan, walk us through what changed last night.
Late last night, about 11:50 p.m. Eastern, USCIS posted a memo ordering an immediate hold on virtually all immigration benefits for nationals of those 19 countries. According to NPR and ABC News, it covers green cards, naturalization, asylum, even replacing a lost green card, or getting travel documents. The Washington Post reports the pause is indefinite and can only be lifted by USCIS Director Joseph Edlow, who signed the memo.
What's the memo actually called, and how broad is it?
It's Policy Memorandum PM 602-0192, and it instructs officers to put an adjudicative hold on all form types for the affected nationalities. ABC News, drawing on AP, lists forms like I-485 for green cards, N-400 for citizenship, I-589 for asylum, I-90 for replacement green cards, I-751 for removing conditions, and I-131 for travel documents. NPR notes exceptions would need direct approval from Edlow or his deputy, so the default is stop everything.
And this is tied to that June travel ban, right?
Right. It builds on Presidential Proclamation 10,949, which President Trump issued on June 4, 2025, about 6 months ago. That proclamation used the INA's 212F authority to limit entry from 12 countries entirely and to tighten screening for 7 more. The difference, the Washington Post explains, is that June's ban focused on people outside the country, while this memo reaches inside the U.S. to people already here.
How far inside? Who's now getting re-reviewed?
The memo orders a comprehensive re-review of approved immigration benefits for people from those countries who entered on or after January 20, 2021, the start of the Biden administration. CBS News reports that means potential new interviews that can't be waived and fresh national security screening under terrorism and security grounds in the INA. Within 90 days, USCIS has to prioritize cases and refer high-risk ones to ICE or other agencies.
Remind us which countries are on that list.
12 have full bans under the June proclamation. Places like Afghanistan, Iran, Libya, Somalia, Sudan, Yemen, and several in Central Africa, as reported by BBC News and NPR. 7 more have partial restrictions, including Burundi, Cuba, Laos, Sierra Leone, Togo, Turkmenistan, and Venezuela. BBC, referencing internal guidance shared with CBS and confirmed by a USCIS spokesman to the New York Times, says the administration is considering expanding the list to as many as 30, though nothing formal has been announced as of today, December 3rd.
Why did the administration escalate now?
The immediate catalyst was the Thanksgiving week shooting near the White House in late November. Just days ago, ABC News, NPR, and BBC have all covered it extensively. A 20-year-old National Guard specialist, Sarah Beckstrom, was killed, and Staff Sergeant Andrew Wolf, 24, was critically wounded. The Washington Post and CBS News report the suspect, Ramanullah Lakanwal, a 29-year-old Afghan national who arrived in 2021 under Operation Allies, welcomed and received asylum in April 2025, has pleaded not guilty.
Does the memo actually mention that case?
It does. The language cites that incident, along with identified concerns and the threat to the American people as a reason for the broad hold and review. BBC and PBS report that President Trump has blamed Biden-era policies for enabling the suspect's entry, framing it as part of broader dysfunction tied to migration and refugee programs.
What does this mean for people with appointments this week?
Many are already seeing cancellations. Immigration lawyers told ABC News and the New York Times that clients from countries like Venezuela, Iran, and Afghanistan had green card interviews and citizenship oath ceremonies abruptly scrapped in the last 24 hours. NPR has highlighted refugees admitted during the Biden era now facing re-examinations that could, at least in theory, end in revocation.
Oath ceremonies, too? That's the last step to citizenship.
Exactly. Those ceremonies can take years to reach, and they often happen in public halls with flags and family members. According to ABC and NPR, even those final steps have been frozen for the affected nationalities. USCIS spokesman Matthew Tragesser defended the move, telling BBC and The Guardian that, quote, "The Trump administration is making every effort to ensure individuals becoming citizens are the best of the best. Citizenship is a privilege, not a right," end quote.
How are advocacy groups reacting?
With heavy criticism. The Guardian and Democracy Now! Quote immigrant rights groups calling it collective punishment that penalizes law-abiding families for one tragic case. They argue it unfairly sweeps in refugees, asylees, even Afghans who worked alongside U.S. forces. People PBS NewsHour notes are now stuck in limbo.
You mentioned Afghans with special immigrant visas. What's happening there?
Separate from this USCIS memo, the State Department has halted all SIV issuances for Afghan allies, according to Sky News and immigration firm Fragomen, which tracks these changes. That adds another layer of uncertainty for evacuees who assisted U.S. missions and were promised a pathway to safety. The Guardian underscores that some of these individuals have already been living and working in the U.S.
Legally, can the administration put a hold on cases inside the country like this?
That's where it gets contentious. INA 212F gives the president broad power to bar entry, but doesn't explicitly address domestic adjudications of people already here. Analyses by Fragomen, AILA, and PBS suggest stretching that authority to re-review approved benefits and freeze all forms for post-2021 entrants could draw due process and equal protection challenges.
Have any lawsuits been filed yet?
Not yet. As of this morning, December 3rd, the ACLU, SCOTUS blog, and Westlaw docket searches, as cited in news reports, show no TROs, injunctions, or lawsuits specifically targeting PM 602-0192. But several groups have signaled they're preparing challenges, echoing the legal battles over the earlier travel bans.
Does the memo give a timeline for the hold?
No end date. The Washington Post notes the pause is indefinite and only Director Edlow can lift it. Inside 90 days, USCIS must produce a prioritized list of cases for deeper screening. But that's about process, not a sunset.
What about people who already have green cards from those countries?
The memo doesn't automatically cancel lawful permanent residence, but the Washington Post reports it orders a re-review of approvals for nationals who entered after January 20th, 2021. Which could include green cards granted since then. That could lead to new interviews or, in rare cases, referrals if national security grounds are suspected.
Are there other restrictions tied to this moment?
Yes. ABC and CBS reported a nationwide pause on asylum decisions announced last week ahead of this broader freeze. NPR also pointed to a pre-shooting memo requiring reviews of all Biden-era refugee admissions, and the Washington Post has tracked Edlow's posts about re-examining green cards from countries of concern.
How does this fit into the broader Trump immigration agenda this year?
It's of a piece with the administration's 2025 crackdown. The Washington Post and Congress.gov have chronicled moves against birthright citizenship, tighter asylum rules at the border, and funding pressure on sanctuary cities. This latest hold extends that posture into the heart of USCIS's domestic workload.
You mentioned potential expansion to 30 countries. Is that imminent?
It's under consideration, according to BBC, which cited internal USCIS guidance shared with CBS and confirmed by a USCIS spokesman to the New York Times. But as of today, no new proclamation or list has been published on uscis.gov. Any expansion would likely mirror the June framework, but officials haven't announced specifics.
What are the national security arguments we're hearing from supporters?
Backers say the government has a duty to reassess risk after a deadly incident near the White House. Outlets like Forbes and LiveMint have framed the move as a necessary pause given evolving threats, from terrorism to organized crime and cyber risks. USCIS says it's about tightening vetting to ensure only fully screened applicants advance.
And the human costs advocates are warning about?
CBC and the Times of Israel highlight families separated by paused travel documents and long-term residents who can't finalize citizenship or travel to see relatives. For Afghans, especially SIV holders fleeing Taliban rule, Sky News and PBS describe an acute sense of betrayal after years of promised protection. Those stories are now colliding with an open-ended bureaucratic freeze.
How are naturalization applicants affected today and this week?
For nationals of the 19 countries, oath ceremonies are on hold, even for people who've passed exams and cleared background checks. The New York Times, citing immigration attorneys, describes ceremonies halted with little notice, sometimes the day of. And NPR notes that interview waivers aren't an option under the memo's re-review rules.
What should affected families do right now?
Stay in close touch with attorneys and watch uscis.gov for updates, because the authority to grant exceptions sits with the director's office. Though the pause is sweeping, the Washington Post reports there's a mechanism for case-by-case exceptions, however narrow. And if lawsuits land, courts could impose temporary restraining orders that change the picture quickly.
Are state attorneys general likely to jump in?
They're watching. The ACLU's local affiliates in D.C. and Texas say immigrant-heavy states like California and New York are monitoring the policy closely, but as of midday today, no filings were public. Given their prior roles in litigation against the travel bans, legal scholars told PBS to expect rapid action once plaintiffs are lined up.
Does this affect people who filed before June's proclamation?
The key date isn't when they filed, it's when they entered the U.S. If they're from the listed countries and entered on or after January 20th, 2021, the re-review can apply, according to CBS and the Washington Post. That's why even long-pending cases are suddenly frozen.
How is USCIS handling its workload with this hold in place?
The memo orders a prioritized list of cases within 90 days, which means triage rather than normal processing. ABC News reports officers must flag potential national security concerns under INA Sections 212A3 and 237A4 and refer those to ICE or other law enforcement. Routine adjudications for the listed nationalities are largely paused while that machinery spins up.
Could Congress step in?
It's conceivable, but unlikely to be fast. Congress.gov lists the current immigration slate as focused on border enforcement and sanctuary funding, not curbs on Executive 212F powers. Any legislative push would face the same partisan trench lines that defined earlier battles over the travel bans.
Do we know how many people this could eventually touch?
Not precisely. USCIS hasn't published a headcount, and agencies rarely break out caseloads by nationality in real time. But given the forms covered, from green cards to N-400s, the universe is large, and NPR says even a short pause could ripple through court dockets and family timelines for months.
What should we watch for next?
3 things. First, any court filings seeking emergency relief, which could come this week. Second, whether USCIS issues clarifying guidance or narrowly tailored exceptions, particularly for military families or urgent humanitarian cases. And third, whether the White House or state adds countries to the list or signals an end date.
Bottom line this morning?
As of today, December 3rd, the policy is in force and cases are frozen for nationals of the 19 countries. Even if they're already living here, the administration frames it as a security reset after a deadly shooting. Advocates call it a punitive overreach that punishes entire communities. The stage is set for a legal test of how far 212F, can stretch inside the United States.
Ethan, thanks for breaking that down for us.
Thanks, Grace.
San Francisco just launched a landmark lawsuit over ultra-processed foods. Chloe's here to break down what it means and who's on the hook.
It's a big swing, Grace. Yesterday, so 1 day ago, the city and county of San Francisco sued 10 of the country's largest food and beverage companies in San Francisco Superior Court. According to NPR and CNN, City Attorney David Chiu says these firms engineered a public health crisis by designing and deceptively marketing ultra-processed foods. The complaint runs about 100 pages and draws a direct line to the tobacco lawsuits of the 1990s.
Which companies are named here?
The list includes household names Coca-Cola, PepsiCo, Nestle USA, Kraft Heinz, General Mills, Kellogg's successor companies, Kellanova and WK Kellogg Company, Mondelez, Mars, Post Holdings, and Conagra Brands. The Washington Post and the Los Angeles Times note these firms make everything from Pepsi and Coke to Kit Kats, Sour Patch Kids, Cheerios, and Lunchables. San Francisco argues their products are engineered to be hyper-palatable and push people to overconsume.
So what's the core accusation?
The city says these companies knowingly crafted products that are uniquely harmful, then sold them as safe and even nutritious. CNN reports the legal backbone is California's unfair competition law and the state's public nuisance statute, arguing unfair and deceptive acts that burden public health systems with astronomical costs. Chiu put it bluntly in a statement quoted by NPR, saying, quote, "They took food and made it unrecognizable and harmful to the human body. These companies engineered a public health crisis, they profited handsomely, and now they need to take responsibility for the harm they have caused." End quote.
That tobacco comparison keeps coming up. Why?
The Guardian says the suit emphasizes parallels to big tobacco, marketing to kids, targeting marginalized communities, and downplaying or concealing risks to keep sales climbing. The New York Times, as referenced by The Guardian, quoted Chiu saying, quote, "It makes me sick that generations of kids and parents are being deceived and buying food that's not food," end quote. The argument is that, like tobacco, the harm is systemic and the costs are public, so the remedy should be broad.
What exactly counts as an ultra-processed food in this context?
The Los Angeles Times explains the city leans on definitions like the NOVA framework. Industrial formulations with minimal whole food content and lots of additives, emulsifiers, colorings, and flavor enhancers. Think chips, candies, sugary cereals, frozen pizzas, chicken nuggets, energy drinks, and even some items marketed as healthy, like certain breads and granola bars. The suit says the specific combinations of additives and processing techniques are designed to trigger cravings and mimic addiction-like responses.
Is there science backing that up?
There's a growing pile. The Washington Post and CBS News point to a major global review published last month, so November 2025, linking ultra-processed foods to harms across every major organ system. NPR highlights a CDC report from August showing UPFs now make up over 70% of the U.S. food supply, with kids getting more than 60% of their calories from them, and adults over 50%. Researchers quoted by CNN, like UCSF's Kim Newell-Green, say mounting evidence ties these products to type 2 diabetes, fatty liver disease, heart disease, colorectal cancer, depression at younger ages, and more.
And that addiction angle?
The Washington Post covered a July 2025 Nature Medicine paper co-authored by University of Michigan psychologist Ashley Gearhart, arguing these foods are, quote, specifically engineered to hit the brain like a drug, rapidly, intensely, and repeatedly, end quote. According to that work, apples or brown rice don't produce the same rapid reward spike. The lawsuit leans on that body of research to say the harm isn't just about sugar, salt, or fat. It's about the engineered formulation and how it shapes behavior and metabolism.
But NOVA and definitions of UPFs are controversial, right?
They are debated. The Guardian and CBS News note some American Heart Association and Mayo Clinic researchers worry Nova can be too blunt, missing the nuance of nutrient fortification or whole grain content in certain packaged foods. Still, as The Independent reports, more than 32 studies associate higher UPF intake with worse health outcomes, and the city argues the weight of evidence, imperfect definitions and all, supports action.
What remedies is San Francisco asking for?
NPR and SF-Gate say the city wants to stop what it calls deceptive marketing, especially to children, and force funding for independent consumer education on UPF risks. It's also seeking financial penalties, restitution, and abatement, potentially billions, to cover public healthcare costs and drive changes like reformulation or removal of specific additives. The public nuisance framing is meant to let a court order broad corrections, not just issue narrow warnings.
How is this different from past lawsuits that failed?
Courthouse News Service points to a big one, a December 2024 class action in Pennsylvania, dismissed this August for not linking specific products to a plaintiff's illnesses. The Philadelphia Inquirer reported the judge said it didn't meet basic pleading standards on causation. Here, San Francisco is saying the harm is industry-wide and cumulative, and it's the deceptive marketing and engineered addictiveness that create a public nuisance. Morgan & Morgan, which filed the earlier case, is now co-counsel with that strategy shift.
Have the companies responded?
As of today, December 3, 2025, NPR and the AP say none of the 10 defendants have issued direct public responses. But the Consumer Brands Association, which represents many of them, told the Los Angeles Times there's no agreed scientific definition of UPFs and warned against demonizing processing over nutrition. Food Dive reports the CBA says companies follow FDA standards and are cutting sugar and sodium while boosting protein and fiber, though that doesn't address the lawsuit's core claim about deceptive marketing and public costs.
Any evidence yet that these firms intended to make addictive products?
Not publicly. Courthouse News Service notes the complaint draws parallels to past tobacco tactics, including historical links when tobacco companies bought food brands decades ago. But claims Journal reports there aren't internal emails or R&D memos in the open yet. Those would typically surface during discovery, much like in the tobacco cases when internal files changed the game.
What's the timeline from here?
No hearing dates are posted yet as of today. SF-Gate says the San Francisco Superior Court's online civil case portal will eventually show the docket, case number, and filings, but brand new cases can take a few days to process. You can search by parties like City and County of San Francisco or Coca-Cola once it's live.
How does this fit into bigger policy shifts?
The Washington Post and CBS News say scrutiny of UPFs has been rising nationwide, from school food rules to federal nutrition debates. California passed an October 2025 law to phase certain ultra-processed items out of school meals over the next decade, building on the state's earlier bipartisan definition of UPFs and bans on specific additives tied to behavioral issues in kids. San Francisco also points to its track record, fights with tobacco, lead paint, and opioids, plus that 2010 curb on fast food toy giveaways, as proof it's willing to push corporate accountability.
Wasn't there also a national push to limit UPFs and assistance programs?
There has been talk about restricting ultra-processed items in SNAP and setting tighter caps on added sugars, salts, fats, dyes, and preservatives. The Guardian notes unusual political overlap on that front this year, even as broader health policy fights remain contentious. San Francisco's Chiu told the New York Times he disagrees with some administration views, but said, quote, "Many of the perspectives of this administration are not backed by science, but this is different. Even a broken clock is right twice a day," end quote, framing it as a rare point of agreement on food policy.
What's the city's basic theory of harm?
NPR summarizes it as a collective injury. Ultra-processed foods flood the market, displace healthier options, and create population-level disease burden and healthcare costs. The complaint claims companies marketed these products as safe or even beneficial, with kid-friendly mascots and health-leaning labels, while their own science teams understood dependence and health risks. By the city's account, that adds up to unfair competition and a public nuisance that taxpayers have been forced to fund.
What makes these foods uniquely harmful in the city's view?
CNN explains they're not just high in sugar, salt, and fat. It's the engineered mix, the speed of absorption, and the additives, like emulsifiers and certain sweeteners, that can disrupt the gut and metabolism. The Independent notes research linking UPFs to higher risks of depression, anxiety, cognitive decline, heart disease, and even all-cause mortality. The city argues that when a product is designed to override satiety signals and hook repeat consumption, public health systems pay the price.
How big is the exposure if San Francisco wins?
It could be large. The Los Angeles Times says damages aren't specified but could mirror tobacco settlements, given the scale of the alleged harm. Beyond money, companies could face court-ordered reforms to marketing and formulations, which the Washington Post says could set industry-wide precedent in a market worth more than $900 billion.
Do consumers need to change anything right now?
For now, nothing legally changes today, but CBS News reports nutrition experts continue to recommend shifting toward minimally processed foods, whole grains, fruits, vegetables, legumes, while watching labels for added sugars and long ingredient lists. Even with debates over definitions, The Guardian notes the safest bet is to treat highly engineered, multi-ingredient snacks and sodas as occasional, not everyday, choices.
How are the companies likely to defend themselves in court?
Expect them to challenge causation and the legal framing. The Consumer Brands Association previewed the argument that processing alone doesn't determine healthfulness and that FDA-regulated products shouldn't be lumped together. Courthouse News Service says they'll likely push on the lack of a universally accepted definition of UPFs and argue the science is associative, not definitive for specific products.
Could this spark similar suits elsewhere?
Very possibly. The Washington Post reports states watched tobacco litigation for years before jumping in, and public nuisance law has become a template in opioids and lead paint. If San Francisco clears early hurdles, cities and states could file copycat cases and even settle for marketing changes and education funds without going to trial.
What signs should we watch for next?
Look for the case number to post on the court site and the first case management conference date. Early motions to dismiss will preview the legal fight over public nuisance and how broadly it can reach. And if discovery proceeds, the Los Angeles Times says internal marketing and R&D records could be pivotal. Those documents often define courtroom narratives.
Remind us what's at stake for families.
NPR's Shots coverage points out kids now get most of their daily calories from ultra-processed products, and that early exposure can shape lifelong habits. UCSF's Kim Newell-Green said, quote, "Mounting research now links these products to serious diseases, including type 2 diabetes, fatty liver disease, heart disease, colorectal cancer, and even depression at younger ages," end quote. The city argues that curbing deceptive marketing to children is the fastest lever to pull.
And the big picture question the lawsuit asks?
Whether companies that design and promote products in ways that drive population-level disease should help pay for the fallout. The Guardian frames it as a test of how we regulate foods that are legal, profitable, and popular, but increasingly tied to chronic illness. The answer could reshape packages on shelves, ads on screens, and the fine print on nutrition labels.
Any timeline on when we might see movement in court?
Realistically, weeks before the docket fills out and months before substantive hearings. SF Gate notes new filings can take a few days to hit the public system, and then the first scheduling conferences follow, so we're early in what could be a very long case.
Chloe, thanks for walking us through a complicated story with big implications.
Happy to help, Grace. This one will be worth watching.
Here are some other headlines. Brussels sprouts a big objection to Brussels-based assets. The European Commission rolled out a €90 billion lifeline for Ukraine over the next 2 years, largely leveraging frozen Russian central bank funds. Belgium, custodian of roughly €190 billion parked at Euroclear, slammed on the brakes. Foreign Minister Maxime Prévost branded the reparations loan mechanism the worst of all options, warning of legal landmines and Moscow-made blowback. Belgian officials want cast iron, binding liability sharing from fellow EU states before boarding this train. With Ukraine's budget facing gaps through 2027 and warnings it could run dry by spring 2026, the clock is ticking to the December 18th EU summit. No deal could force joint borrowing or leave Kyiv cash-strapped as the war nears year 4, testing EU unity under heavy weather. Down Under draws a line up top. Australia's under-16 social media ban takes effect December 10th, with platforms from Facebook and Instagram to TikTok, X, Snapchat, Reddit, and YouTube required to take reasonable steps to keep kids off or face fines up to $50 million Australian dollars for systemic breaches. The e-Safety Commissioner wants monthly report cards on closed accounts starting December 11th. The government stresses penalties hit tech giants, not parents. Google calls the law rushed. Meta is already sweeping out suspected underage users. As a world-first test of strict age verification, Australia is forcing a Face ID of the internet's growing pains. Privacy and feasibility now trending, whether platforms like it or not. Airbus hits turbulence but keeps cruising altitude. The plane maker cut its 2025 delivery target to about 790 jets from 820 after discovering that metal fuselage panels on a 320 family aircraft supplied by Sofitec Aero missed thickness specs. Up to 628 aircraft face inspections, including 168 in service. After a recent solar radiation-related software recall affecting 6,000 A320s, investor nerves went into a stall, delivering the stock its roughest ride since April. Still, Airbus holds its financial flight plan, an adjusted EBIT of €7 billion, betting this panel beater won't dent the bottom line. Ballots and brawls over data. The Justice Department broadened its legal blitz, suing 6 more states, Delaware, Maryland, New Mexico, Rhode Island, Vermont, and Washington, for refusing to hand over unredacted voter registration data, including driver's license numbers and partial Social Security digits. That brings the tally to at least 14 states in the DOJ's sights. Attorney General Pamela Bondi says accurate rolls are the cornerstone of fair and free elections. Critics, led by Rhode Island's Greg A. Moore, see unconstitutional overreach and fear data cross-checks with Homeland Security could cue a purge under a citizenship pretext. The court fight could redraw the map on federal state power and election administration, call it a test of checks and imbalances. Sticker shock therapy delayed. Hopes of extending enhanced Affordable Care Act subsidies before year's end are flatlining. Senate Majority Leader John Thune says there's no clear path forward, raising the odds the pandemic-era tax credits expire December 31st. Without action, premiums could double for some families, and roughly 4 million Americans may drop coverage. A promised December vote appears to have coded blue, with Democrats blaming a lack of engagement from Republicans and President Trump. The prognosis: higher costs, a rising uninsured rate, and sicker risk pools, because when subsidies vanish, the bill tends to come due. That's all we have for now. Today's episode was made by Alexander King with GPT-5, Gemini Pro 3, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.